moderate our conversation on free speech in the age of the internet, I'm delighted to introduce Patrick Cabot, a native Clevelander. Mr. Cabot is a fellow of the Information Society Project and was the inaugural program director of the Knight Law and Media program at Yale Law School, where he co-founded a legal services clinic dedicated to advancing First Amendment values and protecting news-gathering rights in the digital age. His forthcoming book, entitled Subsidize This Book, examines new business models for journalism and their applications for the democratic public sphere. Please welcome me in welcoming Patrick Cabot and the panelists.
Thanks, Leon. This is an honor to have this panel here to talk about the internet. There couldn't be more perfectly positioned folks to talk about some of the emerging issues and access to information online and the freedom of speech. We have with us Cindy Cohn, who's the legal director of the Electronic Frontier Foundation. It's a powerhouse public interest group that brings lawsuits protecting our interests and civil liberties online. We have Alan Davidson here from Google, who's their director of public policy in the Americas and opened their Washington, D.C. office. And we have David McCraw in the New York Times' general counsel's office. He's the assistant general counsel, a position he took from his previous position with the New York Daily News. And appropriately enough, given the subject of our discussion today, we have Jeffrey Robertson, QC, joining us from London, where he's acting for Julian Assange. And we'll have him join us on the screen when the video link goes through. But before we have him, hi, Jeffrey.
Hi.
Jeffrey, I'd like to start our discussion to talk a little bit about WikiLeaks and set the stage for where we're at in the WikiLeaks saga and what implications it might have for free expression online.
Well, let me begin with the poet, John Milton, who 350 years before the invention of the internet said that the attempt to censor information was like the exploit of the gallant farmer who thought to keep out crows by shutting his park gate. And it's really a case of inventing a scarecrow, I think, to stop information coming through organizations like WikiLeaks. The WikiLeaks phenomenon is really based on, let us remember, the First Amendment freedoms based on the ideas surfaced out of the Pentagon Papers, the idea that sunlight is the best disinfectant, that the infected citizenry is the only way in which people should live. And of course, at the European ideals like the importance.
Jeffrey, I'm sorry, we're having a bit of technical difficulty in having you come through. Let's see if we can get the feed corrected, and we'll bring you back in. But maybe, Cindy, if you want to tell us a little bit about some of the issues that have been raised by recent developments in the WikiLeaks matter.
Well, I don't know about recent developments in WikiLeaks, but I think it's important to set the context in which the WikiLeaks situation created. You know, we now have over 1 trillion documents that are marked classified on one level or another in the United States. About 4.2 million people have some level of security clearance in the United States. And 1.4 million have top secret security clearances. So we're living in a culture of a lot of secrecy on the part of our government. And there have been reports, several U.S. commissions over the years, including one chaired by Senator Moynihan in the mid-90s, and the 9/11 Commission, that have pointed out that we massively overclassify information in the United States. And I think that the WikiLeaks saga comes up in that kind of a context, and it's important to remember that the documents that WikiLeaks has released are not the highest top security clearance documents. They're actually some of the lowest levels, some of the stuff that's available to 1.4 million people already. And I think it's in that context with a time in America where government secrecy is very, very high. And there's a lot of unease, I think, among the population about some of the decisions that are being made, especially around national security and foreign affairs issues based on all of this secrecy, that something like WikiLeaks emerges. And, you know, I've long said that if WikiLeaks hadn't existed, we would have to, it would be created. And I think the particularities about WikiLeaks itself are less important than the overall phenomenon of people wanting to have more access to information about how their government is making tremendously important decisions. I think it's fair to say that one of the things that WikiLeaks demonstrates is that while there are certain members of the mainstream media who are doing a lot to try to get information out, it's not sufficient. And alternative ways to get information out to the people about what their government is doing with their tax dollars and in their name was inevitable in this particular time.
I guess one lesson that people sometimes take away from WikiLeaks is the idea that it is, in fact, entirely uninterrupted, that you can have a seamless document dump, and that there aren't any real intermediary steps that can frustrate a leak. Although your organization has done a lot of work with exposing some of the choke points. I don't know if you want to talk a little bit about that, Alan or Cindy.
Yeah, I'm happy to. Certainly, as my organization has been around thinking about the internet and free speech for 21 years now. And one of the things that might not be that is readily apparent once you start looking into the bones of how this stuff happens is that there are a lot of intermediaries. There are a lot of your speech online. Frankly, it's true largely offline as well, but depends on a lot of people in the middle who host the speech, who host your domain name, who might be intermediaries if you're using a platform like a Facebook or a Twitter where you've got a service that is a platform, or your ISP, or the domain name system. These are all things that are necessarily, have to be working in order for speech to get out. Luckily, there are a lot of them still, and if one gets blocked, you can generally find another. But WikiLeaks has experienced many of these problems. They had their domain name seized a few years ago, and was part of a group that helped them get their domain name back. They have had their platform problems on various platforms, and very famously, of course, PayPal was decided at some point to stop processing donations to WikiLeaks, which itself caused a backlash. But I think it's important as we think about free speech in the age of the internet to really look seriously at how the technology works and make sure that if we really care about free speech, that we protect the intermediaries all the way, that are necessary all the way, and allow them to have the freedom to simply pass the packets and not be in a situation where they have to serve as little mini censors on behalf of the bigger censor. That's much more the situation we see in China now, where internet service providers find themselves in a somewhat guided guessing game about what the Chinese government doesn't want Chinese people to see, and therefore implement censorship schemes in order to try to stay on the right side of that. I think to the extent that we threaten some of the protections that exist now for intermediaries, there's one called the Communications Decency Act, Section 230, that's tremendously important. And some of the other protections that intermediaries have, we start sliding into a situation where these intermediaries face pressure to become censorship tools rather than neutral platforms where anyone can speak.
Alan, you've got a great perspective on this, I'm sure.
Oh, well, thanks. Thank you for having us here. To start with, I think WikiLeaks is a great example of both the opportunities and the challenges that the internet today presents to all of us. So on the opportunity side, start with the fact that we have 2 billion people online now. It's a totally amazing growth rate for the internet, and it continues to grow. We've talked a lot about the opportunities for people to get access to information, to access to ideas that they never had before. WikiLeaks is a great example of that. In this kind of trying economic time, it's also worth recognizing that the internet is now this incredible platform for economic opportunity. So McKinsey just released a study in the spring, for example, looking at about a dozen different OECD countries. Looking at the last 5 years, 21% of the GDP growth in the countries they looked at was attributable to the internet. So the internet is now, and I think this probably rings true to a lot of us, but the internet is now this platform for finding information, but it's also a platform for small businesses, for people building their businesses, building global reach in their businesses. And there's a lot of studies out there that are showing how important it is for creating jobs in the U.S. economy now. So against that backdrop, we have these challenges, and I think the old conventional wisdom was that the internet was going to be this unstoppable force for freedom. If you've got the internet, you've got freedom. I think the new conventional wisdom is you better check the old conventional wisdom, actually. Governments really do have a lot of power to control what people see and do online. So, and it's not just outright blockages of content like we saw, for example, in Syria during some of the Arab Spring protests, where there was an absolute cutoff of the internet. There's a Freedom House and the OpenNet initiative. Some of these groups who research free speech online now documented over 45 countries that they can put in the category of internet restricting countries. Google has had its services blocked, outright blocked in over 25 countries in the last few years. Things like, in addition to places like Syria, places like Turkey, where for most of last year you couldn't get access to YouTube at all because of a dispute about some videos that claimed that the founder of the Turkish Republic was gay, which, by the way, is a crime in Turkey. So, note to self. The point, I think, is that there are a lot of challenges to speech out there, and we can't just take it for granted. The new battleground is about the intermediaries, as Cindy has said, and we've got to really look at what tools we can find to make sure that speech is going to be protected when the next 2 billion people come online, which is happening.
I see we have Jeffrey back with us. Jeffrey, we were just talking about intermediaries, and we were talking about how a lot of the choke points happen in between the speaker and the audience, and particularly in the international context. You've had a lot of experience with different types of libel claims where people are requested to pull or censor speech. Could you tell us a little bit about that?
Sure. I mean, one of the first things that courts have to decide internationally is where you sue for something which is wrong. Let's face it, we're all talking about the delights of freedom of information, but what if the information is demonstrably untrue? What if the information severely impinges upon someone's reputation by telling falsehoods about him or her? You have to have some sort of corrective system in the country where that person lives. And so there have been a series of cases. I think I did the first in the High Court of Australia, representing Dow Jones, which had published material about on the net about an Australian. And the answer that the Australian High Court came up with was you can sue anywhere in the world where American-specific material can be downloaded, could be the subject of a libel action. And of course, in many countries they don't have the First Amendment. In many countries they have the opposite of the First Amendment. In Britain we have a very severe libel law which involves damages that would be contrary to American law. So it is a very important question that the world has not yet answered as to how you actually correct demonstrable errors on the net. That is a problem that we have to grapple with at the same time as we talk about the importance to the general public interest in advancing democracy in the world of what I think Václav Havel called the power of the powerless. And this is the great thing, I think, about WikiLeaks and similar organizations, that they've let people throughout the world know what their government is up to. They've let them know by, admittedly, leaking material from US diplomatic archives. It's extraordinary history. It has also brought home to people in Tunis and Egypt and Libya, all over the world, how corrupt and how crooked their politicians are. Now, that's, of course, if you like, one of the really surprising things about the WikiLeaks revelations have been how principled and pragmatic US diplomacy is. It stands up pretty well, in fact so well that I think President Putin thought that WikiLeaks was probably a CIA plot. It has presented a State Department view of the world, but nonetheless, to many people deprived of that information, it has been very important to them, and it has advanced what is and should be general American views of advancing democracy and combating corruption. But still, there has been this almost schizophrenic reaction of American authorities. In the first place, they've trotted out the Espionage Act as a threat to Mr. Assange, although they don't have there's not the slightest suggestion or evidence that he actually groomed the young 22-year-old who, along with hundreds of thousands of other young soldiers, had access to this information. They have used standover tactics. The State Department last November sent letters to PayPal and MasterCard and Bank of America and Visa saying this operation is illegal, which it wasn't, in my view, but nonetheless that letter encouraged those organizations to withdraw all facilities from WikiLeaks, which had a severe effect upon its fundraising. So that was an example, if you like, of an interorum threat that was done behind the scenes against an operation that was not illegal in the places outside America, for sure. And indeed, the best advice is that it wasn't illegal under the Espionage Act. But threatening the Espionage Act with this long-running grand jury that's investigating Mr. Assange, my American prosecutor friends told me that a grand jury would indict a ham sandwich. So you never know what's going to come out of that, but it's long-running, and it remains a kind of threat to those who want to use the internet for what are public good purposes. Of course, there is finally another question that we should be aware of, because it's being raised very acutely, and that is whether providing information uncensored to the world would put lives at risk. All sorts of people last year in America thought that people would be killed in reprisals as a result of this, and indeed everyone from Joe Biden to Sarah Palin described Mr. Assange as akin to a terrorist. But the hard fact is that no one has suffered reprisals of that sort. There are no blood on WikiLeaks' hands, and of course there have been diplomatic embarrassments. People have had to be withdrawn occasionally, but as Hillary Clinton said when she, telling of how she went to apologize to some European heads of state about things said about them, they said, well, you should hear what we say about you. So it has not had the dire consequences, but nonetheless it does raise, I think, a real challenge for those who say no censorship at all. It is the question of whether and to what extent there should be redactions of names before this secret material is published. But secondly, I suppose the anterior, the fundamental question is whose responsibility is it to protect sources of information? And I think the correct answer is that the prime responsibility for protecting your source lies on the government organization that attracted those sources in the first place. It seems to me that if diplomats are to rely upon sources inside a country which may be a dictatorship or whatever, then they bear the prime responsibility for protecting them, which means encrypting them and ensuring that their names aren't widely circulated, certainly not widely circulated for a 22-year-old soldier to get access to them, if Bradley Manning did. But secondly, it means that responsibility to keep information secret lies on the government, and if they fail, they cannot blame publishers, whether it's Julian Assange and WikiLeaks or their supporters and coordinators, the New York Times and The Guardian. They both seem to me to be publishers. They cannot then prosecute publishers for what is, in effect, their own negligence.
Well, Jeffrey, I'd like to put that to David McCraw, because there's 2 points there that I really like, one of which is that American press protections were one of the reasons that that partnership was initially sought, and also that the concerns about sources are, in many cases, people's concerns are mollified by the veneer of a responsible news organization going through and redacting documents. And I think both of those points are worth our consideration.
Yeah, thank you, and thank you for inviting me here. This is probably the 9th or 10th time I've talked about WikiLeaks in these kind of forum, and what I've found is that WikiLeaks is really sort of a Rorschach test, that people look at it and come to their own conclusions. There are people who say that it was an example of the end of mainstream media, that now you have everybody can be a publisher, everybody can go directly to the people. WikiLeaks didn't really need the New York Times, the Guardian, Der Spiegel, and the other publications. They could take it directly to the people. Others, of course, have looked at it and said, well, no, this really is a reaffirmation of what the mainstream media has done and done so well, and that is make decisions, act with responsibility, cull information, and decide what's important and what should be published. I gave a speech in Hungary shortly after all of the publishing had started, and there you saw just how differently people in Europe looked at this. That the first question I got was whether I thought that the WikiLeaks revelations would convince Congress to liberalize FOIA, change the Freedom of Information Act, because this stuff was obviously so valuable. Why wasn't it always open? And I assured my Hungarian friend that that was not the reaction of the United States government about WikiLeaks. You know, I think it's easy for us on this side of the industry, and the publishing side of the industry, or people who are concerned, as they should be, about internet freedom, to diminish the importance of secrecy. But I'm a lawyer. I depend on secrecy every day of my life with the attorney-client privilege. I couldn't do what I do without that. And one of my jobs at the New York Times is I'm our crisis coordinator. And so when somebody gets kidnapped, I'm the person who's responsible for setting in place the plans to try to get the people back. When David Rode was kidnapped by the Taliban and held for 7 months, we went out and we asked major news organizations around the world, the United States, England, Al Jazeera, and so forth, not to publish the fact that he had been kidnapped. And we received a great deal of cooperation, voluntary cooperation. That was important to us because we thought it would undermine our ability to get David back, and we appreciated that people use that kind of discretion. But that said, it becomes clear to me that the real problem for democracy is not unauthorized leaks, but really government secrecy and we shouldn't lose sight of that as people talk about WikiLeaks, that while I acknowledge the importance of secrecy, the real danger that's being done in this world to the human rights movements, to people's lives, to the democracy is being done in the name of government secrecy. Alan spoke the challenge Google faces. I was in China in April, and the last day I was there, I went on Google in Beijing and put in the term freedom of the press. There were no hits worldwide. There is not a single reference to freedom of the press that you can find if you use Google in Beijing. It would be funny if it weren't so tragic. So, you know, I do think that from the New York Times standpoint, we did what I thought should be done. That we took a look at the cables, we took a look at the documents, and we made decisions about what should be published, concerned about things that would expose people who worked in cooperation with the United States governments or our allies, concerned about those things that may have had impact operationally. And so in some ways I don't see WikiLeaks as a game changer. I do think, though, that it raises the possibility that there's going to be a new debate about press freedoms in the United States, which have been premised on the idea, as Patrick said, of a responsible press making decisions. I'm not sure how the courts will feel as they go forward, looking at now extending press freedom, knowing that it will reach bloggers and leak sites.
I guess it would be interesting to hear about some of the mechanisms that are used to promote government secrecy then. I mean, there are anything from domain name seizures to subpoenas of reporters, and I think there are some new frontiers opening up, specifically with domain name seizures, where the government can ask people to take entire chunks of the internet offline that perhaps we could talk a bit about.
Sure, we've been involved in some of the domain name seizures, the ICE, the Immigration and Customs, I lose track of all the acronyms. Folks have been seizing domain names for, about the last year or so. It's started in the realm of copyright, which is unfortunately one of the things we see a lot online, is that lots of things that would, I think, strike anybody who cares about freedom of speech as just rampant censorship if it was done based on defamation or some other legal claim. When it happens in the name of copyright, there is kind of a collective shrug, including sometimes in the courts. But it is very troubling that the U.S. government has deployed its forfeiture authority for things like seizing drug-making equipment to the internet in the form of seizing domain names, which has the result, of course, of taking down a whole lot of speech. And in several cases, taking down speech that, in a case called Roja Directa in New York, speech that had been declared legal by the Spanish government. The whole domain was taken down. I find this to be a very troubling precedent, and I worry that copyright infringement might be something like the thin edge of the wedge for new censorship schemes. We see the difference between the way the Digital Millennium Copyright Act deals with claims of copyright infringement, and if you compare that to how we deal with claims of other kinds of wrongdoing, you can see a very stark difference in how quick it is and how quick it is that you can take speech down and how hard it is to put speech back up again. So it is something we're watching closely and very deeply involved in, and I look forward to the day where the rest of the media who lives off of free speech will join us in recognizing this new threat.
I was saying before, I think that that the battleground has in some ways shifted to intermediaries.
Yes.
I can tell you now, whenever a member of Congress or probably a politician all around the world, when they see something they don't like online, the first call is often to Google's office in Washington, D.C. And we do hear a lot of complaints from people when they see things and they think that we will somehow be able to, remove some of the content that is offending them. Of course we can't. We're simply an index. You could remove something from Google, but it will still exist on a website out on the web. And we try to explain this patiently to people to varying degrees of success.
When I get those calls, I tell them to call Google.
Okay.
It's funny, I don't do anything about it.
The fun thing is that we tell them to call the New York Times, because we can take it out of Google and it'll still be there.
I wonder why people are mad. I don't know.
Yeah, so this is just one of these games. But what's happening is the notion is that people are really beginning to focus on the intermediaries rather than the speakers, and that has it has some difficult properties. It's satisfying to come after the intermediaries. It may be a greater choke point, and by intermediaries I'm thinking about, certainly search is a good starting point, but also the ISPs, the service providers who give people internet access. The telephone companies in a lot of countries are a choke point. The major publishers, and the platforms for speech. Those are the new targets. And again, it's not just the blunt instrument of censorship that we've seen in the past, which is a real threat, particularly internationally, and that is a real issue now. The China example, the Syria example, what happened in Egypt when they cut off internet access for 5 days. But it's also the rules of the road about who's going to be liable for what content. So we had a great example in Italy where 4 Google executives have been recently held criminally liable for a video that was published in 2006. It was posted on Google's video website, video service at the time. It's a terrible video. It's a video of a group of high school kids really abusing and teasing an autistic classmate of theirs. And Google took the video down as soon as we had notice of it, but it had been up for a period of time. And the Italian courts found that we were liable for not pre-screening all of that content. Well, I can tell you that right now on YouTube, Google's video platform, there are getting the statistic. It's probably it's in excess of 40 hours of video uploaded every minute. Every single person, since we've been talking, there have been weeks of material uploaded, right? Every single person at Google could spend all of their time looking at those videos, and we would never be able to appropriately pre-screen them, not to mention who knows what the law is in these different jurisdictions. To hold the platform liable is going to have a tremendous chilling impact. We simply wouldn't be able to offer the services that we offer. And that would be true of the Facebooks and Twitters of the world and all the other ISPs and platforms out there. So this is the challenge. It becomes more subtle. It's not just about this direct censorship. It's about the rules also, about who's going to be held responsible for content. We want there to be more content. We're happy to, when there's a clear rule of law, to deal and respond to those kind of court orders to take content down. But there is this open question about liability that I think is going to be a big one.
And there's a related issue along these lines. We live in a world now, in our digital world, where so much of our personal information is actually being held by third-party intermediaries. If you have Gmail, all of your contacts Google has all of your contacts if you use Gmail. And I represent Birgitte Jonsdottir, who's a member of the Icelandic Parliament, whose information was sought from Twitter. As part of the WikiLeaks grand jury investigation. So the intermediaries not only face pressure to be the direct censors, they're also the holders of a lot of information that the government would like as part of investigating various people. And right now, the standards for when that intermediary has to hand over your information to the government are very, very low. Most of them were set in the 1980s in a law called the Electronic Communications Privacy Act. It's been amended several times. The Patriot Act did a number on those things as well, ratcheting down the level of proof that the government has to present, in some places to zero, in order to get information about your online activities from your service providers, from those intermediaries. So the case that I'm involved with involves Twitter, but the same is true of Google, of Facebook, of any of these intermediaries. And when you think about what they have, in addition to the content of your communications, which has one layer of protection, they have a tremendous amount of information that's non-content. That's who your contacts are, who you talk to when, how long you talk to people, what is the circle of your communications. You talk to somebody who talks to somebody who talks to somebody. And we're really in the midst of a battle across the country to try to raise those standards to a level that I think fits what people think their privacy ought to be. If it used to be that if the government wanted to know who you talk to, they had to knock on your door with a warrant and search your house to find your letters. And the fact that you now keep your correspondence housed at Google or at Facebook or at some other intermediary, we don't think should change the level of protection that not only the content of your letters, but who you correspond with should have under the law, that this technological transformation shouldn't result in a ratcheting down of your privacy interests. Why? Because, of course, the ability to communicate privately and the ability to protect your identity in certain situations, communicate anonymously, has always been thought to be part of free speech, to fight back against the chilling effect that might otherwise happen. And this is an ongoing fight that EFF is in, not only in the Twitter WikiLeaks case, but in cases across the country.
I would just jump in and say, we really support this effort to try to raise the standards. We really appreciated the collaboration with groups like EFF. But one thing that we can do right now is actually just try to shine a light on what's happening out there. So one thing Google has done is to create something we call our Government Transparency Report. If you type in Google Transparency Report into your favorite search engine, I'm told this works on Bing as well, you will get a map of the world that shows, we've listed, we do this on, I think, on a biannual basis now, all the totals of how many requests we've gotten from each government, either for information about users in the country or to take down information on the internet. And that's just a starting point. It doesn't, there's more we would like to be able to do to provide even more granularity, but we're hoping that this is something that a lot of companies will do to try and at least shine a little bit of a light on where all the requests are coming from, and how we respond to them.
One last thing, there is, I'm sorry, we're just double teaming here, but the group that is trying to change the Electronic Communications Privacy Act that EFF and Google are founding members of is called the Digital Due Process Coalition, and a lot of companies, some that may even surprise you, have joined us in trying to reform the laws. And EFF has a little scorecard that we call Who's Got Your Back? I think it's called Who Has Your Back. They made me change that.
I hope we have your back.
And we have a little scorecard with little stars. We give gold stars to companies when they join the coalition to try to change the law, when they give notice to their customers, when the government comes knocking and asking for information about them, when they stand up for their customers in order to fight back. And several other, when they make their policies about government access to information transparent to the user, so you can tell what these companies are going to do. So we have a little gold star campaign, and we're encouraging more companies to go out there and reach for the stars. Let us give you a star.
And let me just put a cautionary note on this, because obviously I am a person who values privacy. But I am concerned, and I know Google and others are, about a movement that's the right to be forgotten in Europe, which is sort of the extension of this idea that I have a right to not have my information, even if it was once public, to continue to be public. And Google, I know, is facing legal threat in Spain and elsewhere about having public documents online because they may have information that somebody no longer wants, or somebody no longer believes in the public interest. And we were kidding up here about these requests for takedowns, but at the New York Times, where as we've improved our search engine optimization and our stories come up higher, we get more and more calls from people who believe that information that was once public should no longer be public. Now, many of these are in the category of nice try. They're usually people who don't want their wedding announcement up anymore. Okay, they regret having married that bum. Okay, they want to live privately with that regret, not to have their neighbors know. I've had people call and say, my kids are now old enough to read. I've never told them I was married before. Would you take down my wedding announcement? I say, I'm glad your kids are subscribing to the Times. That's a problem with young people. But, and of course, at the wedding ones, there's this sense of, we didn't go out and find this news. They came to us to have their wedding announcement put in the newspaper. So, but, more seriously, people who feel that the report of their criminal conviction 10 years ago no longer is anybody's business. Their the wrongdoing. I had somebody who, as a young person who knows this story, was a socialist and was quoted in the New York Times. He's now pretty close to the Tea Party. I don't want people to know that was once my view. Those kind of things concern me. I think legislating amnesia is something that totalitarian governments were good at. It concerns me when enlightened governments are taking that playbook.
Jeffrey Robertson, if you're still with us, I think this might be...
Yeah, I am indeed. What I bring an international perspective, and oddly enough, a perspective that is rather more concerned about aspects of dishonesty and lies on the internet, and of course there are plenty out there. Perhaps we British care more about words and think words have more impact than Americans do, but we do want some kind of protection against lies. Now, WikiLeaks, we all know where it comes from. It comes from American diplomats, what people say to American diplomats. We can evaluate the information from that perspective, but in many cases, facts reported as facts are utterly untrue and extremely damaging. And it's the experience, certainly with Google, has been very poor. We had a case recently where someone was the victim of a false story, a vicious false story in Australia. The publisher in Australia actually took it off and paid damages and apologized. But would Google take it off? It had it up, and it took 3 weeks before Google agreed, at the behest of the original publisher as well as the victim of the attack, to take it off. On the other hand, I can well accept that in many countries, local courts, often judges who are under the thumb of the dictatorship or judges who are corrupt, would order material to be taken off, which is in fact the truth. So what it seems to me the intermediaries should work towards is some kind of advisory board that can assist in actually identifying the kind of court orders that should be ignored because they come from repressive laws or repressive judges or governments, and should, however, in those cases where items can be proved demonstrably demonstrated to be untrue, should be prepared to take them down. It seems to me this is the next step, that we perhaps ought to be seeing the intermediaries make common cause through organizations of the kind we've heard about tonight, to actually obtain fairly authoritative advice on what orders from courts in foreign countries can reasonably be obeyed and which should be ignored.
I don't. You know, we represent a lot of people who are trying desperately to keep their speech up against the forces of pretty significant forces that are often trying to get it taken down. I don't, you know, certainly intermediaries have the discretion to decide to take stuff down or leave it up under the U.S. CDA 230, and I'm comfortable with where that law is. I guess I would hesitate to put the thumb on the scale much further than that, because
I'm not suggesting the thumb should come down. May well be more be published. Just think to be aware. Discretion is all very well, but you ought to be aware that some material that you're not carrying is important to be carried, and some material that you are is simply false and should not be carried, at least without a warning.
And I think this raises a really important point, particularly for small publishers. I mean, folks like the New York Times have able counsel to help them think through these problems. Same thing with Google. Perhaps 3 weeks should have been faster, although when you're managing tens of billions of web pages, 3 weeks might actually be good, but we could work on that. I think the harder problem is honestly going to be for the smaller publishers, especially when you look at this international situation, because we can try to evaluate when an order comes in, what to do about it. And if you look at that transparency report, you'd see that there are literally thousands of times this year where we have taken content down because of a valid order. I think this is a really hard problem for a lot of small publishers, small newspapers, who don't have the resources to evaluate an order that they might get or a request they might get from halfway around the world.
At this point, we're nearing the end of our time, but it would be a good moment to ask for any questions there might be from the audience. Left. Yeah.
Good morning. I'm a local legislator, and many of my colleagues are here today. And I had a question about the internet and what we're struggling with here locally relative to the use of the internet when it comes to law enforcement and criminal behavior. And this example is the flash mob issue. And I'm interested in your response on the balance being struck or not being struck within local government, especially in dealing with the issue of the use of the internet, the use of social media, that ultimately leads to criminal behavior, whether it's criminal flash mob. I'm not talking about the dancing and singing, but the mob, when you actually have someone trying to create a group action that is criminal. And what we're finding here with the ACLU and others, that there is the battle between what is the balance. And so the social media should not, of course, protect one from doing criminal behavior. The question is, how do you strike the balance? And I'm interested in your response.
Well, I live in San Francisco, and so we recently had a pretty public incident where the people who run BART, which is our part of our local transit system, unplugged the internet from BART because they were afraid about a protest. BART cops have a pretty bad reputation of shooting people, killing people in San Francisco, and it's a troubling problem. And there was a threatened protest. It's not even clear that there was going to be one. And BART unplugged the internet. I think it's very clear that that unplugging the means of communication is not the right answer to the fears that people might communicate in a way that helps facilitate social protest. The FCC is looking into what BART did, and I think rightfully so. We were very, very troubled by that. And certainly there was discussion about it in the UK after the protests there. I mean,
I could come in on that.
Yeah.
Can I explain what happened in the UK? Because it was this problem writ large. You had pictures on the internet and on television, indeed, of riots throughout the country and people walking into well-known shops and walking out with television. And it was very tempting, particularly with people who had that propensity already, to go and join them, to go to the nearest Walmart kind of shop and walk out with television. And then there was the social networking, where of course people got on it and said, Walmart down the road is being looted, come and join us. And the Prime Minister actually recommended initially that in these situations the police should have power to, television shouldn't report show contemporaneous pictures of looting, and that the internet should in some way be closed down if this ever happened again. And so that was, I think, perhaps the initial and automatic reaction of the legislator faced with a seemingly new problem from a new device. But after a while, people thought this through and thought that the answer wasn't for television to turn its cameras away from pictures of contemporaneous looting. The answer was for it to show police arresting the looters. And the problem was with the lack of police rather than the television cameras. But in relation to social network, there was a lot of discussion about whether we should adopt a kind of Iranian position. And indeed, some smart aleck politician, I think it might have been Mr. Ahmadinejad, immediately jumped on David Cameron's remark and says, see, England is learning from Iran what to do. But in fact, of course, in due course, the answer was not to close down social networking sites at these times, because it proved over the weeks to come a treasure trove for the police to actually really work out who was behind the rioting. And of course, those who've been made use of the social media networks have now been brought to court and sent to jail for fomenting riots. So in fact, the immediate reaction of, as it were, the legislator to close down the cause of the problem has not, the censorship reaction in fullness of time in Britain at any event, has not been thought to be the correct one.
Cindy, you had a thought on that?
Well, and I think a similar response is the right one here. You know, there's a lot of actually case law and constitutional law arising out of the civil rights movement about when it is you prosecute somebody for calling for political protest and where that line is. The Claiborne Hardware case is a very famous First Amendment case along these lines. We've been through a time of social unrest in this country and where we've had to sort out what's the line, what is creating a political protest, and when do you draw the line over to incitement of violence. I think that case law is good law, and I think that those lines were drawn carefully and during a time where people were just as concerned about possible violence as part of a social movement of one form or another as we have today, and that we ought to just hew to them. I don't see a need to revisit it simply because there's a new technology. In fact, it strikes me that turning to the technology, the social network provider, is to try to demand responsibility here is simply a way to divert attention from the real problem, which is there are people who sometimes are doing bad acts, and the fact that we don't prosecute the people who make the hammers because you might use a hammer to do something wrong. And I think social networks, we should look at the same way. They're just a platform, and trying to create a situation where the platform's responsible for the speech that occurs on it, whether that speech incites violence or anything else, I think is going to lead to a very dark time for free speech. It's hard to know who makes that decision, in what situations, and where we are. We have lines about incitement to violence in this country, and those are the lines that we ought to observe now.
Finally, well, thank you. First of all, that's totally what we're looking at in Cleveland. We have no intentions of dealing with shutting down internets or anything like that. But there is a question that when one is talking about an inciter of a riot who uses a bullhorn versus one who tweets, there seems to be more of a reaction to the tweeter versus the one in front of the mob. So the challenge with us is to look at the individual and how he uses or she uses the social media to do crime. We're not talking about political protest. And it seems to me that we have a much more difficult way when we talk about individuals using social media. Now, we're monitoring it through law enforcement, we're watching sites, but it is a struggle that we are in local government, and it really deals with someone, almost literally a criminal, hiding behind the use of the social media and being protected more so if he was standing in front of a mob. And that seems to be the struggle we have.
It's interesting. I mean, I don't know the specifics here in Cleveland, but, certainly the one thing about digital media that it does quite well is track people in a way that, a guy with a bullhorn might be harder to find. That's a good and bad thing, right? I work hard to protect people's anonymity online in situations where it's called for, and we've worked for a very high test for when you breach somebody's anonymity. But it strikes me that law enforcement, as I think Jeffrey was indicating, there's ways in which digital media might make law enforcement's job a little easier here than it was before digital media. And I think we need to figure that into the balance when we start thinking about whether we want to do anything in response to it. Law enforcement gets a lot from digital media, and we've been collecting law enforcement guides about how they're tracking people on Facebook, for instance. The IRS is a big fan of using Facebook to find out whether you're living large while you're trying to tell them you can't pay your taxes. Digital media gives a lot of power to law enforcement, and I think that when we start thinking about the challenges to law enforcement that digital media might present, we need to think about the whole picture and not just the story that law enforcement's telling about its problems.
Thank you. We have time for one more question. We have 3 minutes remaining in the panel. So to my right.
I'm not sure if you have enough time to answer this, but my name is Ted Dyden, and I work for the Plain Dealer newspaper in Cleveland. I find it interesting that there's such a difference between the libel responsibilities in a newspaper and one online. For example, Jeffrey touched on this a little bit, but for example, we're responsible for everything that we print in the paper, including letters to the editor. But when on our online version, we're just a provider, and people can say anything about anybody they want, and we are not the ones who are responsible for that. And I just wondered what the panel or anybody else had to say about the future of libel protection when somebody has been wrong, there's been inaccurate or worse information, and online, and there it sits, and what protection does anybody have?
Thank you. Jeffrey, maybe you have thoughts on this, and David as well. David, you want to start?
Yeah, it's important to understand the distinctions being made there, which is that when there is a third party who posts something on the Plain Dealer's website or on the New York Times website, the Plain Dealer of the New York Times doesn't have responsibility for that. So your typical comments at the end of the story, we don't have legal liability for. And as the questioner pointed out, not true in the newspaper, we're responsible for everything. But we do have, and this is an important point, we do have responsibility for our own content on the web. It's no different than with the newspaper. Everything that we, the New York Times, through our staff and our freelancers create on the website, we have the same responsibilities we do have in the newspaper. The comment thing, I think, is a very, very tough issue that you've heard up here, just the sheer volume of material that's going up for it's in something like YouTube. Same thing for at a lesser level, but the same thing for nytimes.com. To actually screen and evaluate and do all that would sort of destroy the purpose of it, which is to have a robust speech. But I do think people are very uncomfortable with that notion. It's a matter of federal law, Section 230. And I would not be surprised to see a pushback that people saying that the New York Times, Google, the Plain Dealer should in fact exercise some responsibility of what goes on. That's certainly what's going on in Europe, and I think that it will be a very, very difficult thing for us to do, and I think in the end probably not very good for public speech.
Yeah, I think that... Go ahead, Jeffrey.
Yeah, I think this goes back to the problem I at the beginning of what you do to remove a damaging falsehood that can actually be proven to be false from the internet. The traditional view in relation to print publication and television, for that matter, is that you can sue for libel. But of course, the question is where you sue. In Europe, you can sue anywhere in every country where it is downloaded, and that's not satisfactory. Where you have American First Amendment freedoms that could be subject to discipline, to injunction, whatever, overseas, because that's curbing your freedom to publish. I think what the best legal test is would be that if legal action is to be taken, it should be taken in the country where the publisher is established. In the country where the publisher is established, unless the libel is specifically directed or advertised or whatever in another country, in the country where the victim has perhaps the most obvious reputation, and that would give the right to the victim to sue in the country where he has the reputation, even if its libel law is different to that of the First Amendment. I think that's the only long-term principle that international media law will get to, but it will take a long time.
Jeffrey, I think it's appropriate to let Alan Davidson from Google have the last word on this.
Well, I would just say that the genius of the internet has been its openness, and the fact that anybody can be a speaker and anybody can be a publisher and reach a global audience. We have to be very careful not to chill that. I think we have seen this is the giant debate now facing us, which is the question in some ways about the role of intermediaries. If you make intermediaries the gatekeeper, that I think will have a very chilling effect on speech. And there are a lot of tools that we need to be looking at. We should not take our eyes also off of the direct censorship that is happening out there. We need to use the tools of foreign diplomacy and trade to make sure that the internet remains this open place, even as we grapple with these tough questions about who's liable in the end.
Thanks, panel.
For information on upcoming speakers or for podcasts of the City Club, go to cityclub.org.